Good morning. My name is Mark Silver. I've been presenting a series of programs for immigration, criminal, and civil litigation lawyers. I've been doing forensics for about, over 20 years. I've done well over 3,000 cases and consulted on many, many more. And I've done over the number of years a series of CLEs, continuing legal education programs, for immigration, criminal, and civil litigation lawyers throughout the United States. Tens of thousands of listeners have logged on, and that's wonderful. But I've decided to transfer everything to YouTube so they'd be available without charge for everyone, including those that sometimes cannot afford to pay for CLEs. One of the things I've also wanted to do is present essential concerns that people have had in areas of specialty. And the one I'm going to talk about today is in the context, as everything is, for forensics, which I do, and mitigation, specifically today for immigration lawyers, what happens when they get a denial or an RFE, specifically for waiver cases, but other kinds of cases as well. I want to discuss that a little bit. I want to discuss it because I get a lot of these referrals. In other words, lawyers will get a denial or an RFE depending on the kind of case. They'll have to, of course, call the client and say the case was not granted. And then the lawyer will have the client call me so I can do an evaluation. I just want to start out with a joke, which it's the only joke I know for this kind of stuff. And that is there are two kinds of lawyers. Lawyers who get denials and lawyers who get denials but won't admit that they get denials. In other words, everybody gets denials, including forensic experts who've done cases. If you're working sufficiently in this area over a number of years and you've never gone denial, the only possibility is that you cherry pick your cases. And I once heard someone at an AILA meeting. This goes back about 15 years. She claims she never got a denial. It doesn't matter who it is, but I accept any case that lawyers call me about. If lawyer's case says, I have this incredibly difficult, challenging case because of multiple arrests this person have, or I have this incredibly challenging case because I have a person who I truly think has been the victim of spousal abuse, but I just seem to have no evidence, or there's a hardship case that I have, but everybody seems to be perfectly healthy. They're doing well financially, educationally, and otherwise. I don't say no. I don't say no because I hope every case has merit, and that it is what it is. And so I take very, very difficult cases, and this is one of the reasons I do quite a few criminal mitigation cases for immigration defense lawyers, for individuals who are either in ICE detention or they've committed crimes and so on, misdemeanors of various kinds. And that's the answer. So I don't turn away cases. So these are at times very difficult and challenging cases to begin with. And that's why I said that, tongue-in-cheek joke, pardon me, it's early in the morning, that there are two kinds of lawyers who get denials and lawyers who get denials but won't admit that they get denials. So I just want to make a few very simple suggestions. First, whenever I get a referral where there's been a denial or an RFE, I start de novo. In other words, I look at the case as if nobody has ever seen it before, even if another expert has evaluated the case. And I ask myself, if this case was being referred to me, and no one had ever taken a look at the case, what would need to be done? And that's called de novo. I once heard many years ago a really fantastic seminar from a death penalty attorney who did appeals. And, these are literally life-threatening cases because you have people in capital cases. And the lawyer said, you'd get a huge box of material for the appeal after the person had been sentenced to death at a trial court. And he said, as important as that material was, he would always ask himself, what if I was getting this case from the very first day, what would I do? And that's how I approach it. The second thing I would say is, it sounds contradictory, but it really stands in tandem. What has already been done? In other words, I do look at the previous expert's evaluation, and I see what's strong about it, what's weak about it, what's missing, and so on. I have to tell you, the large majority of cases I do with previous experts, and there's no other way to put this, the evaluations are just inadequate. And they're inadequate usually in multiple ways. One way that the experts' evaluations are inadequate is because it omits criminal mitigation. And I have separate programs on this on my YouTube channel. Criminal mitigation, and I think I'm the only one in the US that does this, but criminal mitigation for immigration defense lawyers is crucial. In hardship evaluations for 601 cases, for example, people focus on the hardship issues, which seems to make sense, when in fact many of these cases, when they're adjudicated, the adjudicator has a particular eye for what triggered the waiver to begin with, and that is the CIMT, the felony, misdemeanor, whatever it is, the crime, if the person entered perhaps through fraud or misrepresentation, and so on. And so the adjudicator may think, gee, the hardships seem to have merit, but nonetheless, I'm going to deny this case because of what triggered the waiver need to begin with, which is the client's wrongdoing. And in the evaluations, this is always omitted. So when I get an RFE or denial as a referral, that's the first thing I consider. Did the expert consider criminal mitigation? And the answer is almost always no. The next thing I consider is, can I take advantage of things that weren't taken advantage of before? So for example, I just saw a case in Chandler, Arizona. And I really wanted to see the clients in person for various reasons, because 3 of the family members had suffered very serious traumas. And I explained this to the client, and we ended up doing through telehealth, through a Zoom evaluation. But clearly, if an RFE or a denial comes through and they want to pursue the matter, I would suggest once again to the client that a live interview is needed, because there were several issues that at least one, if not 2 or 3 of the family members felt quite uncomfortable speaking about through Zoom. Now, why they felt uncomfortable and the context, that's for another time. But it's reality that if we had to do this again, it could be that we could take advantage of the opportunity in a very different way to make the case stronger and flesh out the hardship issues, not just for the family as a whole, but for individuals who have suffered all sorts of very serious challenges and traumas in their history. It's also true that, lawyers like to blame themselves, experts like to blame themselves. We feel responsible as professionals to want to do a good job and explain things as professionally and holistically as possible. But the reality is our clients are also responsible. How many times have you seen clients where you ask for documents, 1, 2, 3, 4, 5, and they bring you, just 1 and 2? Or you say to the clients, we really need to include all the family members because of the hardships of different people associated with the respondent, for example, and the client says that, 1 or 2 of the family members are repeatedly unavailable to be interviewed or to participate in the evaluation or whatnot. And this is a reality. I see this all the time. There's this outside perception that, I sort of speak to my clients, I recommend what they should do and how I can best understand them and explain the case. And they listen to me, they come in and, that's how it works. And of course, that's not how it works. Clients often don't listen to the expert. Clients often don't listen to the lawyer. And clients, frankly, often do not directly listen to judges in immigration court, even when they're trying to bend over backwards to try and understand the facts of the case. And so one thing to ask yourself is, has the client adequately done what they needed to do and participate in the evaluation or assist their lawyer the way they need to And if not, they need to be told quite specifically how the lawyer or me as an expert who evaluates these cases can best understand their concerns and therefore provide perhaps a more detailed evaluation or fill in some of the blanks that were not available when the adjudicator looked at the case. This gets on to the next point, filling in the blanks. It's important that the adjudicator or the immigration judge, whoever it is, does not advance assumptions about the case due to their own biases or prejudices. And it's the job of the lawyer or the expert, whoever's working on the case at a particular moment, to disabuse the adjudicator of biases or prejudices that they may have, particularly with regard to emotional, psychological hardships and so on. I'll give you one or two examples. I've seen cases where people have had certain challenges which objectively may not seem so overwhelming for one reason or another. Or a person may have had a loss of a family member, which, objectively seems quite sad, and, we would be understanding about it, but we wouldn't necessarily be so overwhelming to the person emotionally or psychologically. It's important to fill in the blanks for the adjudicator or the immigration judge, whoever, so that the individuals who is adjudicating the cases won't guess about the case. And that's one of the things I see as an advantage with an RFE or doing an appeal, to fill in the blanks that maybe were not really filled out previously. When you get an appeal or an RFE as an expert, it's not free. Often I have not seen these clients before. Not often. I've almost never seen these clients before. And I charge them. And I may even charge them more, possibly, if it seems to be much more work for one reason or another, particularly if I have to travel or there are multiple meetings or whatnot. And clients have to be aware of that up front. It's sometimes not just work, but it's more work because you're sort of wondering what needs to be available through the evaluation that was not previously presented in the waiver package, for example. Is this a second bite at the apple? When you get to do an RFE or an appeal, it may be, I'm not so sure. I'm a psychiatric social worker with background in psychology. I'm a lawyer, but I don't practice law, so I really leave it to the practicing lawyers who really deal with these things day in and day out. I'm not sure if it's the second bite at the apple. My overall sense with RFEs, and I'm not sure if everybody would agree with me, is that there are two basic kinds of RFEs. There's one RFE where I think the adjudicator is on the fence just looking for a little bit more evidence to bolster the petition so that it can be granted. And there's probably another kind of RFE where the adjudicator thinks, I don't think so. I'm giving an RFE because clearly the lawyer and client has presented evidence about hardships, for example, and the hardship evidence has merit factually and otherwise. So the case does not deserve a denial, but that perhaps the adjudicator is leaning towards denying. I see an RFE as not a bad thing. It could be a denial, but it's an RFE. It's not a grant. But I think that more often than not, the adjudicator is looking for more evidence to grant the case, and in two basic areas: to bolster psychosocial issues that are present in the original application but need to be fleshed out a little bit more. And second, to present perhaps one, two, or three new issues clinically as related to the family, their health, well-being, education, and so on that was not at all available in the first application. it's important for the adjudicator, the immigration judge, not to substitute his or her opinion for claims made by the applicant or the expert in the course of the application. Many years ago, there was a judge, doesn't matter who it was, at 26 Federal Plaza, New York, excuse me, and he would openly give an opinion about the children's health that did not match with the parents' understanding about the children's well-being. And sometimes I think in RFEs and denials you see this. You see the adjudicator providing a substitute opinion but without a factual basis, and that needs to be tackled. There are other issues about RFEs and denials that need to be considered. Where the person is, for example, there are a number of cases I've seen where there's been an evaluation where hardships are considered for qualifying family members. However, the respondent is in ICE detention, perhaps close to the client's home, perhaps very far away. And as a result, the evaluator has not traveled to ICE detention to visit the client. And even if the qualifying family members provide very clear information about the hardships they would suffer if the family member is forced to leave the United States, the perspective of the client can be irreplaceable. That's number one. Second, again, the criminal mitigation aspects of what the client can provide directly are also very, very important. The other thing I find is that in many of these cases where the client has committed wrongdoing, again, misrepresentation, fraud, crimes of one kind or another, I don't see adequate contrition. I don't see the clients really expressing remorse and regret and explaining their error in judgment or their wrongdoing, or explaining it as foolish conduct done in an unthinking moment, or the context, or even if the client has had diminished capacity because of major life stressors. I don't see that coming out in the cases where I have RFEs and appeals. Again, there's a very strong turn to have hardships fleshed out as much as possible, when in fact, I'm a criminal mitigation expert, I see both of having, frankly, almost equal merit. What else can I say about this? The other thing I would really want to stress is that in most of the cases, I don't think that the expert's report where there is an RFE or appeal should be a supplement to the original report. In other words, even if the original report looks somewhat complete, I don't think that the new report undertaken should just be a supplement. As I said at the beginning, I think it should look at the case de novo and have a complete consideration of all hardship issues and all criminal mitigation issues. The one exception to this is that I've seen cases where the cases are delayed for a significant time and the cases have not been adjudicated. So for example, I'll do an evaluation for someone and the case is delayed, including in immigration court, for a very long period of time. And the lawyer submitted the package for adjudication and so on in immigration court. At that point, redoing the evaluation, I don't think makes sense. At that point, I think, an updated report with supplemental material probably would serve to complement and balance the original report in a much more meaningful way. This is also very important because, as it is an immigration court, I'm very concerned that the immigration judge and the TA do not adequately read and reread forensic mental health and expert reports such as myself, which really have key roles in the case. So if they're not going to read one report, they're definitely not going to read two reports. For this reason, having a supplement, I think, makes much more sense than trying to add to the package an entirely new report. Well, that's about it. I just want to give a sense of what I've experienced and some ideas about how to tackle RFEs and denials. The bottom line for me is tackle them de novo, take advantage of the opportunity, ask what was missed, what can be filled in, was criminal mitigation originally considered, and if not, maybe that should now be the center. Is it really a second bite at the apple? Perhaps. I'm not sure. Try to read between the lines of the denial. Look at not just the hardship issues or the RFE, look at just not the hardship issues that are noted in the adjudicator's comments, but look if there's not tucked away, that one line about the fraud or misrepresentation that the client committed, and if that isn't perhaps the real reason that the RFE or denial is coming at this time. And lastly, this is my own bias, criminal mitigation, criminal mitigation, criminal mitigation. Think as much as possible about adding and strengthening the explanation about the client's wrongdoing as much as adding and strengthening an explanation about the hardship factors that are crucial to having the case adjudicated in a way that it will be granted. Thank you again. This is a pleasure really to present these. My information is available on YouTube. Do not hesitate to call me if you have any questions or email me. And I hope this was helpful to you. Thank you.